Why? You are alone. There are hundreds of people where affidavit has been issued. You can give, don't mention all inclusion you can give. It's given the list. Upgradation. If even if we come to this, why? All short matters cannot be taken up. Any urgency. For interest, you wait, please. Question of interest, please wait. This is the pending one. This was allowed to pay there is no upgrade. This way not upgrade. What is the case number? The case is 279, 73. That almost will have a similar kind of pattern on coordinate range. What is the issue? The issue is the constable improvement where information that is we start similar point almost. The order division which has come up with us. Pass an order and that was acknowledged with the ultimately I will first create and the it's appointment matter. It is an yes, they need to come next Monday. Fine. You are to appear. It is your case, not today. You please, if you can inform the other side, you please. ALP matter. ALP. Yes, there was some clarification which was why it was adjourned for one more day, I don't remember. Basically, if we remember correctly, subsequent upon a promotion being granted, he was medically decategorized from 2,400 or 2,300, something like that. He was thereafter placed in 1,900. Grade B. And at that time he was ill. That was medical examination. Pending. Medical examination was pending. Final medical examination was done. Was going on. So the tribunal directed that you may post him on another post if a safety is an issue, but give him this grade. Protect the grade. Protect the grade. Protect the grade. Then nothing remains. You have given it. Yes. Now I think yes, master sir. Yes. Yes, right. Where is that? Can you just point out, please, from the written? In the written answer, filed by the applicant, page. Page 7. Starts from page 7. Number 25. Yes. Para 3. Para 3 is the first page. Para 3. Para 3 and then 6.6 and 6.8. Para 3 process of Yes, 3, 3. Correct. 3, and 6.6, 6.8, 15. Yes. Before the categorization. Then nothing remains to be said. Want to say anything? Clarifications having been. Yes, because this circular more or less it contains the same provision. That has many conditions. Yes, but ultimately the object of both is the same. That if a benefit has been granted, it cannot be taken away. Of course, he cannot seek a posting if there is a safety category or something like that, but the benefit cannot be taken. That is the crux of it. Well, grants. Two. What will rate the employee, the amount was deducted. Due to overpayment made, it was deducted. On the amount. So there is no, the tribunal has not found any fault in the fixation also. Where shows where it has found fault. 64. What does that mean? Where it says that the fixation is wrong. He asked you that the tribunal has not found fault with the fixation. You said it has found fault. Where is the fault? Why do you make an incorrect submission on the facts? Is it going to help you in any? All the cases are. We ask you a question. Why should you give an incorrect answer? Yes. So the fixation has also been upheld. Whatever fixation you say was wrong, that has not been accepted by the tribunal. So what do you want? You want to argue that the fixation is incorrect? Other cases. Give the paragraph number. What are you reading? This is the paragraph of the chapter. This is simulated form. This is another order of the tribunal. It is a different case. So why are you reading it? So if in every case the tribunal should pass the same order. You have an arguable point or you don't have any argument. That will be all the cases. Then why did you file the writ petition? Case of overpayment. Getting the order on the ground of unjust influence. Unfortunate that you should file a writ petition when you know that you have no point to argue. That point arises. How that point arises? You have not argued that if the fixation is wrong, then how it is unjust enrichment? Frivolous writ petition has been filed. The counsel who is standing has no point to argue. You have filed a writ petition only because it is at the government expense. Very unfortunate situation. This is not a sole example we come across every day. The litigation policy we don't know. Minimize or to just file a case for the sake of filing a case, litigation for the sake of it. See, there is a rippling effect. The government exchequer is burdened. They have to come to the High Court unnecessarily. You are at matter is taken up. The predict of service behavior. It's the last year. Right. See, nothing pending for the action work and and now when they join the next for the application. Working as and transferred to and he joined. So now there is no question of any interim order. I was supposed to be why, sir, you are not filing your reply? Can you justify non-filing of reply for 8 weeks? No, if it is correct, will you justify 8 weeks? Okay. Tell them to file it quickly. Oh. Out of the bag. So pretty much relevant. But what happened? I guess that was thereafter I opted the loan I'm going to execute a deed of sale and I am in possession of that. What happened? Thereafter, what I find that one of the best that are more 14. 14. There is an order of the display. So 13.4 was done already. I tell you. Yes. And whether the there were starting my position. I came to know that for my station or my agreement was there, one of the parties international agreement was there, the developer. Prior to that fact was the and whether that particular person wanted to payment of the loan and the proceeding under section 30 and 14 was given. Thereafter, followed with the proceeding. When I came to know about all this fact, I approached the tribunal under section 17 of the Act. My application was dismissed on the ground that this is the time bar. And the time bar. Yes. Because beyond 45 days. Beyond 45 days. Because I am not a follower. I have not known knowledge and regarding that 34. The other person's transaction is prior to your transaction or subsequent? Prior to my transaction. But that fact was suppressed and also there is a proceeding was initiated and the charge was filed that this is a fraudulent act on against the petitioner by the developer as well as that person who taken the prior to me. Now, when I approved my application this is the time was and the 41st and this calculation should be made the 45 days that is for the date of court and not from the date of my I prefer to challenge that that public member also found the order of the date. 45 days has been calculated from which date? From the date of the issuance of 34 notes. From my contention, and what is that date? (13.4) order has been passed from which date? The order passed by the proper order of the district magistrate, so my he asked you if the order passed in 13.4, you are giving us the district magistrate is under 14, not 13.4. Well, that particular date I have no knowledge because 13.4 notice never issued. Never issued. Now you cannot say that. You have come through the proceedings, Tell us the date. Maybe when you approached the chairman, you did not have knowledge, but tell us today. But I don't have the date. So you don't know on which basis, on which basis. The basis is the order of the PM, that is the page 126/11/21. Sorry, 22 to 22. 22 to 22 is 13.4. Then 14 is on which date? Only for 22/5/2020. And it is now on 7/24. 22/5/23 is 14 on. And what is the date on which it was pasted on it? 27, July 20. So that is your date of knowledge. That is my date of knowledge, and I have taken July 24. So more than a year later, they have. I don't have any knowledge, but when it was at least my whole other date of knowledge comes from that. So the only issue is from when the limitation has to be covered. That is the knowledge of the Still coming this capable for this answer. As to that RSPC, consequences applications on citizen. Still we are approaching division issue to decide, see the determination. This cannot be a contentious issue. Whether it is to be before us or before single bench cannot be a contentious issue. Just tell us if it is the determination lie before an honorable single judge, we can all in application. Prima facie, we are in agreement with what you are saying, but let us see the determination. Maybe because we are dealing with the tribunal matters, but this is not a tribunal under 323A or 323B. This is a tribunal established under the Act, DRT Act, as a have a copy of the Act. Do you have a copy of the Act? Sure. Yes, sufficient. Sufficient. No. Just see the determination. Appears to be correct. Not a tribunal under 323A or 323B. Correct. Fix. Just one minute. Yes. Yes. It's 24 education during 16 September 2011. Yes. It's 20. Yes. Second, as last paragraph, it says the certification has to be by which authority? Has to be by which authority? The second last paragraph, page 24, second last paragraph of memo dated 16 September. Yes. Look at the casual because I here says the casual daily contractual workers who have rendered 10 years of service continuously in at least 40 days attendance each year may remain engaged in the same status and in capacity till their attaining age of 6 years. The next counselor of service shall have to be certified by a officer not below the rank of assistant secretary in case of secretariat department, director in case of directorate and assistants, senior SQO BPO in case of regional office. The concerned officer who certifies may be advised to exercise extreme precautions and take assistance of an office of WPSN, WP and SHE. Right at each 40 certification each 41 is the type of a mind. ID SCLS. Sir, subdivisional controller. Was working on the directorate and in terms of the directorate or such order and order of the which is at plus page starts at page 8 and not probably a director of 8 page 8 follows order repeat 10th of December 2024. Which paragraph? Your paragraph line come to page 14. Give us the paragraph, please. Page 14 is the relevant paragraph. Page 14. Of the review. Of the review. Instead of page 7 of the order of the review order. Yes. That word starts from page 30. Sorry. Start from page 30. Internal page 6. Yes.
The further time that the November vacancy in September 2012 required continuity of service to be certified by a competent authority, not below the rank of the director. In case of directorate, to specify this requirement. Pursuant to this clause, if the November subdivision control to the supply of the office where the commissioner was working has forwarded this statement showing details of casual workers working in this office. The communication was sent on 8th June 2000, where the petitioner's name figure and serial number 2 showing his date of engagement as a casual employee before March 1998. There has also been shown the working for days approximately each year as per the statement submitted by the company. If the petitioner's office at the director of the directorate, there is nothing on record to show that this statement has ever been denied, disputed, or rejected by the director. Even if the order asked by the director on 3rd February 2020 is not denied or disputed so far as the petitioner's claim of having served as a casual employee for more than 10 years and having spent 240 days approximately. We therefore find more explanation in holding that there was no basis to valid petitioner's claim of benefits under the they would have completed this whole
You are re-arguing the matters. You are re-arguing the matter. We have not taken this certification to be by a competent authority.
I am not on that. But I am not on that.
Yes.
Instead of this, I have pointed out what is troubling. Troubling the department. What is troubling is
what is troubling is the order. So you want to re-argue.
Yeah.
It appears that is the prima facie opinion we gather from your submissions. You are re-arguing the same thing which we have considered. You started off that we have taken a wrong certification. We have not taken a wrong certification.
Allow me 1 minute. Here we are 1 minute.
You may take as much as time as you. Please take as much time as you. You must be conscious of the limits of the jurisdiction in which you are arguing the matter. What is not the
on this particular case. I say not the petitioner in the present case has passed the case of my lord's eyes of 240 days.
Yes.
I am not disputing on that. Let this observation of your lordship that since it is not reverted, demand document was sent to the directorate and not responded. In this particular case,
that is all we have said.
No.
See, that's why we are saying you are trying to re-argue the matter. That you are putting words in the order which are not there.
Absolutely.
We have not only said that because it is not denied, we have taken it. We have said even in the impugned order there is no whisper. Even in the impugned order, read after that. Then why are you making one? Why are you pointing out only one thing?
I started by saying that your lordship has considered every point in the impugned order. But I repeat,
we may have come to a conclusion which may or may not be. We don't know. But whether this is a question for review, that we have to reconsider everything.
What I very humbly say is that
unwanted litigation.
No, no, my lord,
This is unwanted litigation.
what I say is that my lord, we clarify this.
Government money, you can do it.
Or
Yes.
we got the paper. Only thing I say, my lord,
It's not a question of annoyance. What you are arguing is beyond the scope of the jurisdiction in which you are arguing.
express myself, my lord.
You have expressed yourself very well. On the day before the vacation, you said that we have relied on a wrong certification. Today again you started with that submission. Now you have come to the correctness of the conclusion in the order as if you are arguing a very peculiar submissions being made in a review jurisdiction.
My commission is this particular case, here in 2 lines and conclude. In this particular case, this certification has passed the test of this already.
No, it has not. This certification was never disputed by the director. It sent to him in the reviewed order also. He does not doubt this issue. You have read 2 things, but you are submitting only one. That is why. And you say it is not a case of annoyance. Why should you make a submission withholding something which you have just read? We pointed out. Still, you are persisting on that. It's not a case where we have only said that because the director it was communicated and he did not deny. We said that even in the impugned order he has not disputed this issue. He is the competent authority. So what remains to be argued? Tell us.
Any document that is sent and not responding to that, I don't think can we clarify that part, that much of
What
the
is there to clarify? What is the clarification? You tell us unless we come to a different conclusion, what is there to clarify?
this much, that, this, for what
Please tell us, suggest what is the clarification. You know you cannot. That's what precisely what we are saying. You know you cannot.
it's clear matter.
This you want a rehearing, which is quite obvious. Sorry.
This should not be taking a precedent.
Why should we say? What is the precedence involved?
Because otherwise, what is something else is that any document which is not converted back tomorrow can be considered.
Sir, we may be wrong. No, see, we are not shying away from this. We may have come to a conclusion. This may ultimately be held to be wrong. Then your entire issue will be over. If we are held to be right, then. Oh, we are not. We know the system of how the court functions. There is a series of appeals. There are different forums. We are not on that.
Like that,
We are not on that. We are on this that you file a review in such a matter and try to re-argue the matter. This is not expected from the state.
Very humbly, something that here, I will be clarify that this is for this matter. Since otherwise, any document that's sent from the regional offices to the directorate and not responding might be considered.
Again, you are making only one submission. That is why you should not be saying this. You are reading the judgment not the way it is. You know what is the consequence of reading a judgment not the way it is. You should not read a judgment not the way it is.
I am not.
You are trying to submit that we have accepted it only because it was not controverted. Then why you have this apprehension? Then so therefore it should tell us what is the concept of precedent. What kind of a case this will cover? Please, sir, no. We are on legalities.
I have not very.
So tell us what kind of case this will cover.
I did not cover up any of my apprehensions.
We are saying what kind of case this case will cover.
Any other person here of like nature, but
What is the like nature?
say a similar kind of job.
What?
He could have
That his recommendation has been made to the competent authority. The competent authority has correct to the competent authority. That competent authority does not deny dispute. That competent authority, even in another order, does not take up this issue, and therefore this should not be a binding dispute.
argue on that blood.
Why not? How can you? That is what we are unable to appreciate. How you are arguing on one point.
Second, knowledge or what the authority don't have without deny or this reason of certification because we have never like the tribunal also because relied upon.
We are not hearing the matter again. Sorry, we are not hearing the matter. Yes, take the matter. The they
Yes, I remember this.
have you filed any reply in the country?
But I have kindly
Let them file a reply. How much time? No, you tell us. 4 weeks, 8 weeks, whatever you want. As paid by landed council for the state. We have we don't know. They are maybe let's see what
kindly. That's a period.
you already said how many times you will say that. You heard what you are saying. Yes.
I
Matter the matter of this, whether the issuance of some operation in this matter, whether it comes to the concern of this order, that is page in the order. What is the date of the order? 28/4. Yes. Just wait.
In such circumstances, the court find it proper to dispose the present petition by directing the state respondent RTA Alipur South Chowkis Pargana consider the rest of the petitioner's application in pending before it till the next board meeting when on the date the decision of the authority be informed to the petitioner within 1 month from its decision. Other, the, it has not been stated that when the next board meeting will be held. It has not been told, my lord. Secondly, my lord, the state authorities have not released any total number of application that it has been flat transparent one. The sole contention in this matter that they let these state authorities leave the name of the application that it has been stated that they want the auto rickshaw permission money. And moreover, my lord, the
Is there any procedure requiring them to disclose the name of all the applicants?
no.
Then how are you making such a submission? Are we to write something in the act or the rules?
Whether their application
You are here for enforcement of a right. Where is that right? Show us. Say they should publish the name of all the applicants. Why? Where? It's requirement. That's what you're asking. The prime consideration for issuance of such permits is for the public convenience, road safety. That is the prime consideration. Maybe a beneficiary in that exercise.
cannot permits for all.
You cannot, it has to be a particular number. It has to sustain free flow of traffic, it has to sustain public safety as well as provide convenience by sufficient number practicable within these limitations. This is the concept. So what more do you want? The court has said both will also be considered. Now whether a date has been fixed or not, it is open-ended. What is your instruction?
It has
So something has to be done. Whether you, if the process has to reach a logical conclusion, or you have to abandon it. Either
I don't care. Oh, it is not that's what instruction. You can go by the time frame by which this decision has to be arrived.
that much can but this is an order of April. Till now, nothing has happened.
Wait, the petition, the unit of challenging order granting compassionate appointment in an application file fee with effect from in the first application was very taken.
Yes,
I have nothing to say on that. I am arguing with the presumption that his rejection in murder proceeding when his name was considered against
where is the rejection order? Where is the rejection order?
rejection of well,
Where is the rejection order? You said his rejection in 2003.
no, he has been granted with effect from 2003.
Yes,
In 2003, he was granted. Further, it was not finalized. Ultimately, appointment, his name was recommended. He was not granted an appointment. That was again recast. The panel was recast. The
2003 his name was recommended.
he does after that he does not propose to
He does not.
approach the till 2023. His name was subsequently considered was the second time it was considered, but it was rejected because there was a bar of 3 years. He did not challenge that. Now 2014, 15, 16,
So if we see 2003 to say recommendation,
his name was recommended.
then you say that it was rejected. When? That is what we are asking.
Panel was recast.
Just now you
It was
said
not-
because of delay it was rejected.
So I am saying from the cause of action. Rejection was subsequent.
When? Where is that date?
Rejection was in 2006, it was rejected. 16
All these times it was rejected.
rejected. But in the second time it was in 2006, it was rejected because there was a bar of 3 years from the date of death.
How that bar will apply to him when you have already recommended 2003?
That in 2003 that was not challenged.
Why should he challenge a recommendation made in his will?
No, he was not given an appointment. He was recommended.
Therefore, once you have recommended, where is the question of bar in application now? That means his application was in time. Unless his application was in time, how could you recommend him in 2003?
No. His application was in time.
Yes.
At that time. Subsequently, he does not approach the court till 2023.
So that is a part of the scheme that he has to approach the court after the recommendation.
If he is not granted, violated any legal right, violated the very basic principle, if a legal right is violated, he has to be
Any legal right, you are correct.
any
But a right arising out of compassion, you are arguing the same.
I am saying, I am arguing on the basis that the act of not giving him appointment, we proceed with the presumption that that was bad.
Is that a due stand to be taken by an authority which is to be guided by compassion in this respect?
But we are guided by judgments of conscience.
Yes, which Which judgment says that after recommendation you can sit on it for 20 years? Show us. Don't show us the delay. You have recommended.
But in this
We
case,
cannot put that on the blind spot. We have to see that.
it's still this. It's still.
So in 2003 recommended, thereafter rejected in 6, 14, 15 and 16. Then what happened?
Ultimately, he approached it.
In 23 he filed a OA. What was the cause of action?
He was writing letters. If it is like 13, 17, and 20, he was letters were issued to him informing him that this case would not be closed.
So there is no rejection.
No, subsequently there is no rejection because if the case was
Just now you said there was rejection in 6, 14, 15, 16.
yes.
Where is the rejection? Again and again we are asking that you show us a rejection.
I have. My action will not be material issue of the charges of the I have some
We can see judgments after the facts are complete, after we are clear on facts. You said 2003 compassionate appointment recommended, not acted upon, petitioner no steps. Again he revived his claim in 6. Rejected in 6, 14, 15, 16. Where is one rejection order of 2006, 14, 15 or 16? Show us. You must have filed a reply in the tribunal. Show us from the reply where you have said that this case was rejected. Before the tribunal, show us from your reply.
Page 180, 6.8. In fact, all these chronology has been given.
Show us one rejection, sir. Again, we are asking.
Either can you see paragraph 6.
Yes. Not considered does not mean rejection. That means it is to be considered. Therefore, again and again, we are asking you where is the rejection? You said rejected in 6, 14, 15, 16. Your specific submission that 6, 14, 15, 16, 4 rejection. We are asking you to show one. There is a rejection, then that will close the issue. That was required to be challenged. If there was a rejection, then that will close the issue. So if it was not challenged for so many years, what remains?
What I think there is no rejection as such. They are considered And they are.
So they have been considering in 2003, 6, 14, 15, 16.
Yes, but in 3 years, he did not get marks. 3 of the years he did not get marks, so he was not sure.
That completely changes the entire context. There is no rejection. In fact, there is at least 1, 2, 3, 4, 5 considerations in a period of 20 years.
But yes, it's
Huh?
establish a legal right. So his grievances could be at any point of time. He could have said that I have not been given a point. In fact, it was impact.
Hmm?
His name was impact.
In
For
that you have been doing since 2003.
yes,
That you have been doing since 2003.
no. Only once.
Every
That
no, sir. It was considered again and again.
his name was at least.
He,
Yes. And the judgment also says that. Judgment also says that.
the judgment says that the matter was considered repeatedly, never to his favor. It was all the time deferred for some other occasion. In the meantime, one vacancy which arose for the compassionate appointment was filled up by giving a promotion to someone on that post.
Yes.
Now, all these facts are there. This is the way you are treating a compassionate appointment applicant and keeping him running for 20 years. Every time you take it up, you say not considered. Therefore, we ask you, where is the rejection? If there was a rejection, he would have gone home or he would have challenged. No rejection. He was kept waiting. You have considered
He
him.
has repeatedly applied, he has not got it for some whatever reasons. If it is his case that I should have been given.
So he has applied. He has applied again and again.
He has applied again and again.
So where are the applications?
Application was
After 2003, show us which application.
that's application.
See, because
Application.
if it is what you are submitting is that once the issue is closed in 2003, there is the occasion of any further application.
I am not even on that.
Yes.
I am saying the presumption that is act on the part of the authorities. With the presumption, I am not repeating it. With the presumption that because it was in 2003, hardly have any report. What was the reason why it was in
Don't
the
say that.
well,
Don't show that.
fact is fact. Now, my lord, I am
You would have said so in the tribunal if that was an issue. That for want of records we are unable to say it. That we have not said. You have in your reply you have dealt with everything. So it can't be without records.
well, it might be. I trying to establish a case. Yes, that this is laid up in the matter of compassionate appointment.
Therefore, we are saying if he has applied belatedly, show us. If you have kept the application pending for 2 decades, then can you that be held against him or her, whoever it is?
It is not a case of keeping the application pending.
It is because there is no rejection. You have already failed to show a rejection.
No,
Then we ask you whether he has made an application related. So there is no application.
he has every time he has applied.
The
His
issue
name has the application show the minutes and the minutes and the
either in your reply,
your lordship has wanted
show us from the reply where his application he has made after 2003.
that application, the word should be well. 180. 6.8.
So let us see this rejection. Where is it? Lecture R by 2. R2. One. 150. No.
This is the remote. This is the POPT OM has been, not the rejection order, not the order dated 16. This is the OM on the system table. OM has been.
Mere averment will not suffice. You are referring to all the documents with details. Where is it? Show us one rejection. We are just trying to understand what is your factual assertion. First you said rejected 5 times, we do not find any rejection. Then you said applied again application. What is the fact that you are trying to canvass before you make your submission on the law?
Yet again made an appeal. Yet made an appeal on that thing. So application has not considered. So now we are discrepancies. I am saying that if he converses that he has a right to be, he has a right to compassionate appointment at a particular point of time, he has to say no to that particular point. He has to canvass. What has been is he has challenged that the issue in 2020. And the court has held that since he had to have that part action on your part was illegal, compassionate appointment will be given with effect from that particular date. And I am purely arguing for the basis of observations in the state of delay. Specifically in compassionate appointment.
Therefore, before we go to the judgment, we'll have to see that he is guilty of delay. That is precisely what we are trying to see. From as such in law, what the picture emerges is that he made application on time. Once considered in 2003, then considered in 5-6, then considered in 13-14, then considered in 14-15, then finally in 2020 you say we regret. Till 2020 we do not find any regret.
Same thing. He has.
What do you mean same thing?
Well, the act is that you cannot be considered. We are you cannot be considered.
When?
In 2020.
In 2020. So till 2020 you have kept him pending.
Agree with it. So even if I'm going back to say, but even if appointment is to be given, it has to be given from 2020. It cannot be given from
because you have kept it pending from 2003 to 2020.
Pendency is when an application is filed and it is not acted upon It is not a case because every year on year is possible. So every time when his matter has been considered a fresh cause of action. It is a fresh cause of action. It is not a continuing cause of action. 2003, when he was his name was but not one singular point cause of action.
We have
That
understood what
actually,
you are saying.
that cause of action has not continued. Second time when his matter is taken, that is a separate cause of action. These are it is not a
And
matter that
if like in the instant case, there is a 1 to 5 consideration, and any particular consideration has been found to be wrong,
Right.
then what will be the consequence?
But then another aspect comes in. Even if he has a legal right, compassionate appointment matter will not get because the purpose of compassionate appointment is immediate relief. Those are the Supreme Court judgment I wanted to use. Because all other facts my lord become irrelevant.
No. Whether the facts will determine whether the case law will apply or not.
The case law
The proposition is well established. You need not show any case law.
there is only one case fact, irrelevant fact, when his father died or when his
No, it
father
is not.
can you see the judgment?
When you have considered that also is to be
singular point.
in that case also
That-
there was a delay of 2 decades in considering.
In one of the cases, in one of the in one of the
In
cases,
considering or in applying.
in one of the cases, he was given appointment. That appointment was set aside. Subsequently, it was challenged. Then my his appointment was given at a delayed stage. Court said 6. There is a delay that appointment itself was bad. The appointment itself was bad. So even in this case, in 2000, they had it. These follow action for compassion, compassion approach. That is what they don't very hard and fast. They gave this judgment was not very
Like we will see without seeing the end account. See just with
for rejection method. They are using something. They are saying that's not being considered.
when they
Effect is same.
when they wanted to reject, they have used a different expression. We will show you from the records. When they had decided to reject, they used a different expression from not
In
considering.
2020, they said no more application.
No, it's a regretted. That is the
They-
expression
but
used
they-
when they want to reject. They say now it is regretted.
They
Till
are,
then, they are saying not considered.
now they are saying that it has already been considered so many times. Please do not stop making application.
Now we are making.
The effect is that. Effect is that.
Is the rejection of 2016
Page, page 83.
or 2016?
The word the committee did not recommend a name for conversation.
Now come to the last sentence of this letter.
As you scored much that very small. So, again, each of these events is a separate cause of action.
You are saying everything at the same time. You are saying rejected once and for all, and then you are saying it.
That is subsequent 2020 letter, my lord, not this one.
Therefore, we said for the first time in 2020, you have used the expression regretted.
That is because
Till 16, you are saying it is still to be considered.
That is because he has made application more than five
We have not seen any application. You are making submission without showing any application. So we will not accept this.
Well, from the facts.
Either you
from
show
the pleadings, whether facts which are not disputed.
So show us from the reply that how many applications he has made. Show us.
When his name was considered, I am presuming that he was on the basis of an application.
That presumption will not rely.
All right, automatically compassionate appointment.
Alright, you can record your submission that we should presume that he made application.
Well, I
Was
where a fact is not disputed,
you have to satisfy the court, sir, on the basis of your pleadings. You cannot say a fact which is not there. There is no application. If you want, we give you an opportunity, go through the entire record.
although this more court wants us to give appointment. I identify the financial that
Show us the entire documents. Please, please don't. See, this is not your conference chamber. I don't like this. Please. You come back when you have seen everything. For every query, you are asking the officers. That's not the
application.
Either you come with the documents on the basis of which you are making a submission, or we'll proceed on the presumption or on the finding that there is no such document to support such submission regarding repeated rejection or regarding repeated application. This is a fact which cannot be presumed. This has to be seen for sure as a very valid right which we are dealing with. Get the entire, see, please listen to us. You get the entire records. You come next week, nothing will happen tomorrow. They will not proceed further. Come back to the report.
What at least in some of the
We are already saying we want to conclude the issue. We don't want to keep it hanging after giving a interim kind of a note. Next week we'll fix a date. Ask your officers to brief you with all the documents. And then we will consider the matter. Not go on any presumptions. Be very clear. Either there is a case or there is no case. There is no question of any presumption. Submitted by the learned counsel for the Please go through everything.
But consider the application. I can help me out with this. I am very sure he will not oppose the fact that applications were filed, but unfortunately, I don't have
Then it must be lying in your records. You have dealt with everything date-wise and reference to all the
Yes.
communications.
That's what direction. And application. But direction can
We will see on 20th. But prima facie opinion appears to be, this is not the way you should approach a compassionate appointment.
that one of the guided by. I will convince the lordship at least from the judgment.
I very well appreciate what you are trying to say.
Because the fact there, the relevant fact is
20th, 20th, 20th.
They already want.
Next, next.
Action number 10, the specific digital of which was specific case.
Which tribunal? State. State administrative.
Potentially on this side. Let me finish my argument in my here. Taking note of this is only question of law which was coming from the lordship which I am prepared to answer. So while that is taking note of it and the question is lordship there were two ways. Initial one way was withdrawn, another way was there. But the second way, which was filed within time, that was dismissed on the ground that there was a what should kindly see the date of filing that particular way. What should the way was filed on? It will appear from the order itself. What should kindly come to the page, internal page 2 of the order of the tribunal. Kindly come to this after C that Labor Department order number such and such, dated such as, however, the applicant again made a representation before the authority for consideration of his case of fresh by letter number 24/6/2025. And now Lordship, this waiver filed, Lordship will file from the internal page 3. Internal page 3, your Lordship will file in 7th line, second paragraph, was rejected by the respondent on 19/2015 and the applicant has filed the intent application on 22nd February 2016. What can I take note of this date? 22nd February 2016. This way was filed. And what you kindly come to page 25. Earlier, annexure 8, this is the original application. What you will see on top, there is a stamp which says that 22nd December 2016 was presented, it was affirmed on particular day, 22nd December 2015. Was ultimately filed on 22nd February 2016. And watching the representation, which was, I said 24/6/2015, I made the representation. Watching the case that petitioner's son, who was minor at the time, when his father died in 2011 initially. Immediately after that, she made the application for the compassionate appointment. Now that particular application was ultimately rejected by an order. What you will find it in page number 20, where it stated that at the time of making application, petitioner's son was 5. He did not attain the age of 18 at the time of making the application for compassionate appointment. So, Lordship, this particular order was issued on 19th February 2014.
That was the subject matter of OA 970.
970. After that, when OA 970 was there,
there was two development. One, petitioner made one application, that is on 24/6/2014. That was the representation which was made before the concerned district magistrate and collector.
24/6.
Yes, 24/6/2014. This was my representation against
That was the subject matter of OA 970.
whether
Rejection of that application was subject matter of OA 970.
970. Now, this particular application,
The subsequent OA is 1300 of 2016.
6, that way was presented on
Why that was filed?
that was filed because of some lack in the classification. Maybe there were certain things that cannot be at this point of time. That was the first way was allowed to be withdrawn. When both the ways were on board, on the day when first way was allowed to be withdrawn, second way was on board. And Lordship, the tribunal permitted the first way to be withdrawn against and
Leaving the limitation issue open.
keeping the limitation issue. Now, Lordship, the limitation issue, so far this particular issue is concerned, according to me, Lordship, 24/6/2014 is the date when I made the representation against the decision of rejection of my compassionate appointment on the ground of the age. I made the representation there for employment assistance in the case of died elders in favor of Sri Shubhajit Bhushan to the Malda Collectorate, and representation says
You add now, right now, the intents are not relevant. The dates are relevant.
dates are
24/6 you made the application. Then what happened?
now what happened after that, and we come to the next. This is Roshul, kindly come to page annexure P7. This is the concerned district magistrate forwarded my representation before the Deputy Secretary to the Government of West Bengal. This was on 17/1/2014.
Yes. How it can be?
Then
17/1/14 is prior to
no,
24.
sir. Sorry, it's in next week. 4/9/2000.
4/9.
2014. The Joint Secretary was communicated by the actual district magistrate. Kindly come to page 24.
Then what happened?
Now, these both ways were there. Now, Lordship, the tribunal here, the second way is barred by the now, Lordship, I am falling under section 21P, subclause P of the Procedural Administrative Tribunal Act.
Before you come to the provisions, 24/6/14 application forwarded on 4/9/14. Was it rejected?
Now,
Nothing happened. Then why did you file the OA 970?
970 was filed seeking the compassionate appointment
Or a direction
for a direction.
that the pending application
That
and that situation remained the same till filing of the second OA. All right.
I cannot develop
No, that's all right. Just want to be clear on the facts.
section 21. Section 21 of the Administrative Tribunal Act deals with the limitation. It says a tribunal shall not read section. Remaining. Limitation. A tribunal shall not admit an application in a case where the final order, such as is mentioned in clause A of subsection 2 of section 20, has been made in connection with the demands unless the application is made within 1 year from the
So 1.5 years.
one. So, Lordship, from 14/6
That is what you are trying to,
Yeah.
1.5.
24/6. What 6 months comes like 24 December
15.
2015, and I think
15.
15.
December 15. Yes.
And December 22, I presented. It appears on the CD.
22nd December.
22nd December. It was filed in February 2006. So it was presented on that. It was signed on that. So Lordship wanted to place this court on the issue of law. That is entire before a complete judgment passed by the Supreme Court. The last decision. That is 2025. This is the online AC 916. Now, Chief Executive Officer and others versus case welfare. There Fellowship stated kindly come to paragraph 35, where the law has been concise by the Supreme Court. We hold that except in cases where final orders are passed on appeals, revisions, memorials, and representation, which are categorically provide limitation for the purpose of filing an original application under Section 19 of the 1985 Act, in view of the above referred decision and Section 21 and 20 thereof, has to be reckoned keeping in mind the date of actual of the cause of action and the proximity of the date of representation. So there are two cases: actual of the cause of action and proximity of the date of representation. And the period of 1 year for filing an original application has to be counted from the date of expiry of 6 months from the date of such representation if no order was passed there. Needless to observe, the cause of action cannot be deferred by making it highly related representation and awaiting its outcome. We also make it clear that the different considerations would arise in a case of continuous wrong, which has to be decided in light of the decision. So, Lordship, this was the law laid down, and I found this is the latest judgment of Lordship was very well understood. So, Lordship, this is 1.5 years, and the Supreme Court also want the proximity
The
of the
cause of action accrues after 6 months and you have to file it within a year thereafter.
Lordship, that is the sole contention, and I submit that I am reading that in the zone of limitation. So, the learned tribunal has already law by rejecting my original application solely on the ground that it is hopelessly barred by the law of limitation. So, learned tribunal has allowed the first way to be withdrawn. Thereafter, learned tribunal took up both the matters and ultimately dismissed the original application solely on the ground.
Took up both the matters. The earlier one was already withdrawn. So how it can take up this?
Learned tribunal tried to say that learned tribunal allowed and one to withdraw. But you kindly come to the order.
Just one thing. What is the date of filing of the
Second way, super, it appears from the order, my lord. Kindly come to internal page 3 of the order, second paragraph. The applicant has filed his instant application on 22nd February 2015. And also, I state
22nd February?
February 2016. It was fine. And Lordship, I submitted that it appears from the endorsement, that is the post-field application of the West Bengal Administrative Tribunal. This can be found from page 42. That is filed on 22nd December 2015. 24th December 2015 was the date on which I
Page 42.
page 42.
42 is paragraph page 15 of page 15 of the application.
Page it should be What is the cause? It's the action.
Filed on 22/12/2016. 15.
It cannot be 16 because it's recorded in the order that it was signed on 22nd February 2016.
But this court fee.
In both the cases also, so there are two.
It cannot be 2012. It has to be 16.
This cannot be because it says that second February 2016 was signed.
How can it be, sir? It is way number 1300 of 2006.
That is something, but it's confident record.
Prima facie, it is intriguing. We accept this. Cannot be that within.
Well, it says that we policy recording for this can only be accepted.
Correct, but still that is one way of doing it. The other is if there is a that you have considered a wrong date, that could be verified by the records by the tribunal itself. Quite considered.
Otherwise, also this tribunal
Very
slow down the
with the records. So some special message. Yes. See, my brother is see. Lordship is showing page 27. In the cell on the left corner, on the left side. Page 26. No, not that page. Maybe prior to that. Index. It's just about the just about the
page 27.
That is the index of the UA. Date of filing 22/12/2016. The registrar's seal is there with the signature of that date.
This is 12.
Therefore, we were saying that if that is also 16, perhaps part of it is not legible. Has to be, it cannot be 15 if it is of 22nd December 16, 15. How it can be numbered as 1300 in 2016? Maybe 10, 20, 50 or something like that. And the date has also been fixed on 20th March 2017. This is clear from this. But then how the tribunal has recorded the date of it? Have this 12 has been read as or written as
That date was
what is the concept of proximity in the judgment that you have read? What does it mean?
that your son was
It was not rejected. But the time you filed the way, it was not rejected.
so by the time I filed the second way it was
We asked you, you didn't tell us. We have been asking you, was there any change? You said no change. We asked you a specific query that why did you file the second way? You said because there was some infirmity in the earlier one, therefore.
That was within that time. Not that separated was already there. That's it. When the first way was. First way was like that.
Prior to first way itself,
That is why Lordship would be with.
so then why are you considering the provision regarding pendency of representation?
That
Then that will not apply. 21B will not apply.
if the date is wrong, then
Either representation has been disposed of or not. If it is disposed of, then A will apply. If not, then B will apply.
Lordship, here representation, other representations are not.
Just now you said rejected, then you moved the
Actually, Lordship, they have rejected that and it comes
against the rejection you have filed a representation. How can that be? Once rejected, you are required to come to the court. Where is the question of filing a representation?
it was rejected when the action order. Action order is in page 20. Page 2.
Give us the date, sir, first. Rejection date.
Lordship, this was on 19
You are relying on 21B. 19?
2014. The undersigned is directed to refer the memo of the such and such all the subject mentioned above, and this same in case may not be considered for the employment assistance on compassionate ground, as the petitioner has not attained the age at premeditated time of death of his father, which is required to enter public service in accordance with the Department of Law. So that was on 19,000. Immediately after that, Lordship on 24th, 2015, the representation was made, heading up to the content of the representation. After they paid for the employment assistance in the compassionate ground,
Then how this can be done? If you are not challenged 1914, what relief you will get?
now this 1914 was challenged in the first way of
So much of confusion. Just now you said it was against representation. Now you are saying there is a rejection. Now what have you challenged? We don't know anything.
in the first way, this 1914 was challenged.
19 to 14 was challenged.
In
Why
order
are you relying on 21B? We don't
that was that whether we already did that soon.
How can you when you have
Well, I thought I slept that 13
this is a very relevant fact you have not you are now disclosing
it was recorded as 22nd February. So it was a recording of
whatever it is, you are required to tell us that representation was rejected. If we were of the opinion that you have not challenged 19,
19.
now you are saying 19,
challenged the first.
and in second way not challenged.
In the second way, my lord, in 19 to 2014, in second way, 19 to 2014 was separately.
What do you mean separately? Then there is no challenge.
There is no challenge. There is a challenge in A. So our name is Calcutta, there is in Calcutta 19. A.
If you come out with facts in this way, you expect us to assimilate everything. Can it be done?
19 to 2000. So this was challenge. And there was the additional prayer that I wanted to issue directly responding to this. Second.
So long we are more confused than we should. We should be knowing things clear by now. We are more confused. Start off somewhere else and you end somewhere else. And we have to consider these facts and arrive at a conclusion. You started off relying on 21B as if a representation was pending. Continued with that, we asked you twice, thrice, you said yes. Now you come forward with the fact that it was rejected. Then we don't know whether you challenge it. Now it's saying now that it has rejected, rejection was challenged.
It's the rejection.
If you were clear on the facts, you would have told us at the very beginning. As and when we are asking, you are deciphering the facts in court. Is this the way? This is not the way, sir. We are here to make things simple or make it more complicated. Make it impossible to consider the issue. The clear facts. We are totally, we are left more puzzled than we should be. You should have been clear by now. Please give us a list of dates properly.
We have prepared was
Give us, go through it. Don't give it like this, please. Not today. Give it after you go through it. Don't just hand over whatever is being given to you. Verify for yourself.
options of
Records are to be requisite. For what purpose? We have to sit and look at the records. Also for the question.
plus
16.
11.
I appeal for the petition. I am led by the learned ASG, Your Worship. Worship, I appeal for the petition in this matter. The learned ASG is leaving who is here, Your Worship. He is now on legs in another court, Your Worship. He has requested if the matter can be posted as a fixed matter on Friday, Your Worship.
Break this call.
12. Ticket number 12. 13.
But it has been filed. One. Five. Eight. Eight and out of it, two have been given. Out of eight. Remaining is eight. They have then eight on qualified. Two is four. On qualified pay. Three is the bar not for what given amount. Five not qualified. Six given amount. Yes. The opposition of eight four. Page 4. Paragraph. Page 4 is from the part. From the of position. Before. You are also going to find that think opposition, it's not opposition. Okay, before that. Yes. Yes. That table has been given. Yes. That 8%, they have given this table. 4 and 6 have been given. 4 and 6 have 1 and 2. Here the efficiency is not perfect. Therefore, they are not 1 and 3. They have said that is the non-bank. Therefore, he has not been qualified in the PET. Yes, PET. Yes, yes.
And 7 and 8 are converted into the 8. In my described what I have Calcutta which has been the year of 2010, they have called for submitting the application. We have filed the application. We have included all the documents. They have verified. They have called for critical efficiency.
Lord, may I be permitted, Lord, may I be permitted to say something virtually? Lord, in this
Yes.
matter, Lord, in terms of your Lordship's last direction, Lord, we were required to file an affidavit. Lord, we have filed the affidavit. My learned friend appearing for the petitioner, Lord, wanted to file an exception. He has filed. I have received a copy. Thing is this, Lord, your Lordship wanted to know from me, Lord, whether, Lord, we have completed the process, because that was the direction. Within a certain period of time, process was required to be completed. Now, Lord, we have Lord, tried to show in our affidavit that, Lord, we have completed the process. Out of 8 petitioners, 2 have been appointed and 6 have not been appointed. The reasons have been disclosed why they have not been appointed. Now, Lord, my learned friend appearing for the petitioner is trying to make out another case, which is not, according to me, Lord, to be, Lord, agitated before the learned tribunal. That is not the case here. Your Lordship, kindly consider my affidavit, Lord.
I have
Where is the judgment regarding PET and overage? Give it.
I haven't said it remains 9 in my
Exception.
Lord, if your Lordship, Lord, is kind enough to keep the matter on next Tuesday, Lord, I can take further instruction from my client with regard to the exception filed by my learned friend.
Required. Issue is settled unnecessary institution and their undertaking it has been settled.
Yes,
Yes, done.
clearly stated in
This person at serial number 1 and 2, they are petitioner numbers.
and they have not qualified on the
Petitioner numbers. Petitioner number. What year?
petition number
1 is petitioner number 1.
number 1.
In this table, the person at serial number 1 is petition number 1 and 2 is 2 and 3
Please take
and 5 is 5.
yes, sir.
7 and 8 are 7 and 8. them is a non-matriculate.
He has already passed the
Therefore, he has to pursue his matter. That is petition number 3.
he has already passed.
But at the time it was considered, he had not.
That time
Today, whether
he has already
after passing matriculation, he has not approached.
after passing he has been it has before the
How many times you will say that? You already said that. We are saying after becoming matriculate, he has not approached them. After rejection, giving a matriculation certificate, what is that? The rejection is very much their ground for rejection, and now you are saying not rejected.
another reason you have they have already submitted. They have taken time for the verification of this.
Where is that?
That is also my case, you have already passed.
Where is that? Show us. We are saying it has to be considered.
That we learned that might not.
That will have to be considered by them after the matriculation certificate is given. There has to be a fresh consideration.
Yes, their lordship has said, and they have taken time for 1 month for verification of this certificate and the lordship is next week that matter. And that matter is and bring in that certificate.
Come with it. Come with it tomorrow.
I'm grateful to man.
Voting. Not.
My lord, I beg to appear for the petitioner.
Every day you want an adjournment. You ask him to come. Yes, we are taking it up.
For the
Sorry,
past 3 days, my lord, each and
this can't
every
be
day
done.
they are
Keep the file. Ask him to come. The issue. Yes, what is the issue?
My lord, the matter is that the petitioner was debarred in medical examination. That's why her candidature was rejected. Now,
Debarred in
initially, my
medical
lord,
examination.
physical examination,
EET.
physical efficiency, PET, my lord, physical efficiency test.
Yes.
Her candidature was rejected, and on that ground, my lord, your previous direction was to consider her candidature in the light of the judgment of this Honorable High Court in WPCT 88 of 2022 23. But my lord, they have not considered the candidature, and they have filed one affidavit in this regard. Perhaps they have submitted that supplementary affidavit to your lordships. A copy is already served upon me, my lord.
There is no supplementary. What has been done? They have done anything?
My lord, in the supplementary affidavit, they have relied on the judgment of the Supreme Court, what was already not considered by the previous coordinate benches. My lord, that was Union of India and others versus Sankar Prasad Deep. And my lord, another joint procedure order they have annexed to the supplementary affidavit, what is talking about amending the affidavit, amending the earlier joint procedure order. Before the vacation, my lord, this matter was last taken up by your lordships.
Where is the judgment WPCT 88 of 23?
Yes, your lordships. My lord, it's at page number 256 of your lordship's brief. And my lord, the relevant paragraph in this judgment was at page number 259. The second last paragraph, my lord. Be that as may, we do not intend to enter into the aforesaid aspect. The moment the railways have decided and conveyed the court unequivocally that even a person is not qualified in a physical efficiency test, he will still be considered for appointment on medical test, which is distinct and quite different from physical efficiency test.
It is arising out of way, not contempt.
Yes, my lord, it is arising out of way. My lord, may I give you the brief history of the case? My lord, first, the claim of the applicant
So has
was
it been,
upheld by,
has it been
their,
rejected?
my lord, rejected on the ground of faith.
Where is that rejection?
My lord, I'm showing, my lord.
That rejection was not before the tribunal.
My lord, initially, when the petitioner filed and the original application by the common order dated 26th of by the common order the 16th of March 2020, the tribunal upheld the right of the petitioners to compassionate appointment. Then the concept of physical efficiency test was introduced. Then the petitioner has preferred the first original application before the tribunal.
You
In
asked
that
me
original,
one question whether the rejection was before the tribunal or not. You are giving us the entire history.
my lord, the original before filing the original application, the claim of the petitioner was rejected by the respondents.
Where is that? We don't find that in the order of the tribunal. Show us.
My lord, my lord, I'm showing. My lord,
Presentation.
that my lord, the result starts at page number 316.
Mr. Counsel, please try to understand what we are asking you. Don't just show us everything. We are again asking you that when the tribunal disposed of the way, at that time your representation had been disposed of or not disposed of.
My lord, kindly come to page number
So you
361.
you tell us first, was it disposed of or not disposed of?
My lord, it was disposed of.
Then how come the order records that this representation is pending?
Sorry, your lordship. My lord, there are some technical difficulties, I think, on the internet connection. I'm not able to hear your lordship's comments properly. My lord, may the matter be fixed tomorrow, then so, I can come physically and address your lordships.
Granted time at the beginning. Yes. Yes, not.
My lord, item number 16 is also an analogous matter.
Both matters no. Both matters no. Both matters. Seventy.
Last prayer was not but we have some prayers also
You have not served.
not chapter.
The question is being served.
But
18.
as for the respondent, our officers were
Why have you challenged the order? You have to establish your right. You have to establish your claim. How it can be given to us like
Stipulation. Specific recommended the case. Because of that, Calcutta was mentioned on the statement of the past selection. And also competition for their parties there. And my lord, what is the point? Spite of all efforts, my lord, now, my lord, find out the review. Asked for by the discretion on the instruction of the association. Only she is unable to she that mentioned. Otherwise, only in the system by or by requested that stipulation submit the state copy of the people. Option the accountant where from our father was issued pension payment order.
So who is talking to you? Go and take from the office of accountant.
My lord. My lord, it's not possible. She tried.
It is possible for her to run to the High Court and it is not possible to go to the AG office.
My lord, department has enough power, my lord. This my lord has
Running to the High Court.
Then I'm very
You are not a poor person. It would have been a much easier thing to go and get it from the AG office. You just need to file an RTI application. That is all. Unnecessarily you are coming before this.
Department, my lord. Yes, department.
Sorry. We don't find any reason to interfere with the order.
Only for the my lord, she that mentioned my lord.
Either you show us that PPO is not required, or if it is required, you have to give.
My lord,
There is nothing else.
my lord,
Nothing else can be done. Saying that I am not able to get,
the page particular only
Mr. Counsel, please don't make unnecessary submission.
my
If they are accepting your claim, they have asked you to give PPO.
my
Why you should not give?
my
This you have to show that you are not required to give. Show us where is the.
my lord, kindly.
You can't say that I cannot give. That we will not accept.
Lost time, my lord. Kindly. Coming comment is 99. Division bench in similar case. What observed? My lord. The case of subject of the process union of you. Allow me.
Yes.
Same thing happened in this case. The
Site, listed matter, generating new application, serial number 1, Devargodhar Mohapatra.
Vehicles. Yes. No other matter. Here, go on other. That is that. That does not mean you only have vehicles. And we understand. Order 25. Has been returned. Now he is here. You can give it. That doesn't mean you will appear here also. So that's but if you are appearing, it can. Let him go through. We'll consider next week. Challenge. Any. So next week, let him go through it. That has been adopted. We have not seen anything. Tell us what it is. What is it? Tell us. It is interstate between West Bengal and Odisha. One quota has been given for state of West Bengal. Two applications filed in the same meeting. One is of my kind, another is of my private response. But these applications was allowed. My application was rejected on the ground there is no vacancy. On the same meeting, my application is rejected only on the ground there is no vacancy. On the same meeting, in the same another agenda, where is the latest? Where is the decision? We also definitely. What people just and and 45 in the state of mind. Yes. What is it? Tell us. What is your solution?
Submission is that what once this application was rejected, that will that application rejected, but no challenge has been made in the rejection. Against that rejection. Again, that application is revived. However, that has been suppressed in the order passed by your Yorkshire Planning up to page 40, where he has told that
That case is not before us.
so that is in the request.
That case is not before the court. Nobody challenged that order.
That
Nobody challenged the order of the
yes,
So that is over.
Only
That is over.
Now, they have filed under the opposition before the court.
We are not considering what happened in that case.
How your occupancy this has been not discussed. How one vacancy which has been violated by the link of failure of submission of the documents and things that has been already gone without how the vacancy has been occupied by a person who has already been left the place.
That's all.
This has not been discussed. I made a straightway in the same meeting, my application rejected, taking this application further only as a new application. And that the order is.
It is a new application. What do you mean as a new? It is a new application.
Minor. This application new one.
Your application is new.
No, but that your occupancy.
Your application has been filed in response to which notification of vacancy? Show us. It is in response to which notification of vacancy for that route.
Vacancy has not been declared. So both the applications was taken up, declaring that there is no vacancy. So but this for that occupied vacancy, but that is only applicable now.
Only aspect is, sir, whatever he has been granted under the orders of the High Court. That order is not before us.
No, that is not your logic.
That order is not before us. We are not doing.
That order is, we have annexed that order. In our
You may annex 100 bit orders, but that will not. This will not become an appeal out of that order. This cannot.
Only for my side, you are
Sir, that is.
I will not. I will not.
That is beyond our. That is beyond the scope of the present.
Only take for wait for the.
We are not concerned. We are not concerned. We don't know whether you should challenge it, whether you are required to challenge it. You will do it.
That you lost it. Sorry. Kindly appreciate.
Not in these proceedings.
I'm just for my side, you lost it.
Why should we? Just for your satisfaction, we should see anything which is not.
That was for this.
Not. That will
the order itself
That's all.
clear that he made the fresh application
We don't-
and he asked for consideration of the fresh application.
We
They
don't-
lost it. And whether the state has appeared therein without taking the recourse of the earlier applicant that is submitted. That has also been submitted in law.
That is not before us. We are not going to look in.
That cannot be valid. And when the occupied
That
vacancy
cannot be looked in.
they were at occupied vacancy in my humble submission. One vacancy, if it is valid, that is their resolution. That has been rejected earlier.
In the writ petition, you have challenged this order of this decision of the board dated 12/12/24.
Yes, yes,
Issuing them a permit.
yes, on the ground that the application has already been rejected.
Very good.
So that application, again,
And how the coordinate bench could have undone something which has been done by another single judge.
no, same, that is the important thing.
Sir,
And that has been
Judge
told-
may be the same, but it is a different case.
So that I told you, only thing, I not be, but being my petition,
It was open to you, file a review of that order. It was open to you to challenge that order. You have not done it. What can be done?
the order passed your occupancy point, but the order is of 28th May.
Date is immaterial. It is a separate proceeding. These are separate proceedings. That was the rising out of writ petition. That number is also there.
4323.
Yes, that is a different case.
That is not your occupancy, that also matlab, that your occupancy order, in order. Of the judgment of 28 May, that has been approved.
We are not going to look into that judgment, sir. You may try your best. That is beyond the scope of this intra-court appeal. That is beyond the scope of this intra-court appeal. This intra-court appeal is confined to the judgment of
28 May.
yes.
That I am submitting.
Yes.
Your occupancy.
43 to 325, there is a direction in his favor. The authorities have complied. That is all.
What direction? Because that only have.
No, we will not.
Because there is only direction.
We are not going to
look
look in. We are not going to look in.
Now your that has been quoted by the order.
Yes.
That your occupancy relied on your occupancy. Page 4, page 4, internal page 4 of the judgment. Paragraph.
Yes.
The private respondents relied upon.
Yes.
But that the order, resolution was supported, that the order is very clear, that is appearing in the resolution of the authority also. The resolution of the authority also specifies the order.
Now, even if this thing is for some reason, if it is interfered with, what will you get?
I will not get the party, but
Then
no,
for academic purpose, you are pursuing this.
The resolution adopted without any consideration.
You are interested in something for yourself, or you are interested only to defeat what they are doing?
I have been thrown out from the zone of consideration.
No, you have not. We asked you at the very beginning. Where is the notice notifying the vacancy pursuant to which you have applied?
On that,
there is no vacancy. Then why did you apply? Where is the question of giving you anything? Show us under the act or rules that without vacancy it can be given to you. Without any notification of vacancy, can anything be given to you? It's a pure issue of law. Forget about the facts. So you cannot get nothing. You knew from the beginning that you are going to get nothing. No, sir, there is no declaration of vacancy. No notification of vacancy. Kindly come to page 45. It records that there is no vacancy at this point of time. You cannot get anything.
that is page 45 is in respect of I.
Correct.
Yes, now we are occupancy.
No vacancy at this point of time. Therefore, again, we are asking you, show us the notification of vacancy pursuant to which you apply. Or show us from the writ petition where you have said that notification was issued. Thereafter, we have applied. Show us. Come to the writ petition. Where is your writ petition? Where is your writ petition? Come to your writ petition. Where have you said that you applied in response to a vacancy? Then, yes,
Vacancy.
that's
That vacancy has not been filled up by the. But that
petition through us. Nothing you can do. But then it comes for the why to your rejection order?
My rejection is one line order.
Yes, that's what.
But his grant is your lordship. His grant, which I have challenged, that is not occupied vacancy, your
The
lordship.
parties.
Only kindly one, if it's not there, I will not, if it's not there, your lordship, kindly page 40, page 39.
All right, we'll see page 39.
The page 39 was specifically written here, yeah, all right, private respondent allow vacancy, occupied vacancy.
All right, third
So
party.
occupied vacancy मतलब is allowed, मतलब तो
For final disposal, serial number 2, the state of West Bengal and others. IMP.
Twentieth August, 24th.
Yes.
The application for curtailment has been rejected.
rejected of the law. First of all, any application for variation that should be needed as an application for new permit. It was suggested by the last line of the election that you may apply for a new permit taking that proposed number one. Number two, application was rejected on the ground that if the curtailment is allowed,
the review of the commuters could be suffered or there could be the inconvenience of the public. Now, the learned singers say that in view of the proviso under section 80 subsection 3, cartel pay is not variation to that extent. To that extent, yes. Now, the learned singers say that
So his application has been rejected by saying that it will be, have to be a fresh application.
that was the suggestion made.
Where is that in the order? Which order?
That is my lord the 109 of the order of the transport of the and also tracking of 110 110 will person a will be special depot by model number such and such with respect to the ARQ matter or opinion whether or not the cartel pay will benefit the general public transportation to and fro for the Chokan to Monska, it should be according to the test of the cartel. And now the conclusion is that motor vehicle inspector said that will against the benefit of the movement of common people and so therefore considering all the aspects of the litigation along with the report submitted by ARQ to Qatar, submission of the application or HTA board to take unanimous decision not to allow the said cartel payment of the application as it will not serve the convenience of the public and the Honorable High Court has complied with the order be communicated to the concerned party. In earlier order, which was earlier rejected, it was suggested by Lord that to apply for a new part because of 18. Now my Lord be agreed. Now the learned seekers just say that in view of section 80 subsection 3 proviso, in case of cartel pay, the authority cannot take that plea or cannot take that ground. We cannot issue to that ground that there will be inconvenience of the public. But in case of other variation, that means extension or variation of the route, otherwise not my lord the change of the meaning, then authority can take inconvenience of the public. But we have come up against that particular findings. Because that is totally contrary. Giving this statutory permission. In the party judgment. It was here, various cartel pay, variation includes cartel pay. So one question is whether
Whether section 80 gives us the expression curtailment.
why section 80 subsection 3.
kindly come to section 80 subsection 3. Section 80 subsection 3 speaks that an application to vary the conditions of any permit other than a temporary permit by the, this is the definition variation. Section 80 subsection 3. D. 3. Section 80 subsection 3. An application to vary the conditions of any permit other than a temporary permit by the inclusion of a new route or routes for a new area or by altering the routes or area covered by it, or in the case of a state carriage permit by increasing the number of trees above the prescribed maximum or by the variation, extension or curtailment of the route or routes or the area prescribed in the permit shall be treated as an application for the grant of new permit. First of all, then lordship kindly come to second proviso. Second proviso provided further that in the case of variation, the termini shall not be altered and the distance covered by the variation shall not exceed 24 kilometers. In the case of extension, the distance covered by extension shall not exceed 24 kilometers. Then, my lord, the problem arose according to them. And any such variation or extension within such limit shall be made only after the transport authority is satisfied that such variation will serve the convenience of the public and that it is not expedient to grant by permit. Now the learned court, my lord, came to the conclusion and the finding that this any such variation, this, my lord, the expression any such variation that is the for the that will serve the convenience of the public. It is any such variation, this expression only qualify this proviso, second proviso 1 and 2, Roman minor, where there is no, my lord, whisper regarding the, my lord, curtailment, extension and variation. But our humble submission is that the first subsection 3 itself says the application to vary the condition by way of in this mode. Variation within the without changing termini or extension or curtailment. That is subsection 3 1 that vary the condition in this way. So this expression initial variation cannot be restricted to only proviso 1 and 2 in the second proviso, where according to them that there is no mention about curtailment. So in case of curtailment, according to the learned judge, in case of curtailment, I cannot resort to the public inconvenience. But our humble submission is that first of all, entire transport system is according to
The second proviso does not use the expression curtailment. Therefore, the honorable single judge is of the opinion that in case of curtailment, this will not apply.
this will not apply. Public inconvenience.
But even if it doesn't apply, it has to be treated as a new application.
That will be treated as a new application. That is also one of the 2016 Supreme Court had, my lord, that is the subsection 3 itself says that any such variation shall be treated as an application for the grant of a new permit.
So, for while granting a new permit, this is not to be looked into. This public interest, convenience of the public is not.
Yes. Then in a separate manner, the moment he has to file an application for a grant of a new permit, starting from this point to that point, then again everything will be looked into.
There has to be a report. There has to be a route notified. Everything has to be.
Everything. Sorry, in any public convenience, inconvenience,
Number of
unhealthy competition,
number of carriage already operating.
that means unhealthy competition, everything will be looked into. Only one sentence in that basis for judgment.
Lord, when this Lord, the 1988 Act was challenged, then my Lord, in witness of judgment, when they say, no, the new Act is here, it's the finance and not the finance. Now, my Lord, the Supreme Court said, my Lord, in just one sentence, idea, just there, my Lord, the Supreme Court said that it's a originator of the liberalized policy, the new Act. And my Lord, in one sentence, the Supreme Court in 1996. Come to my Lord, page 176. It's a continuation of paragraph 6. Continuation of paragraph 6. The page 176. My Lord, after my Lord, the about my Lord, 10 sentences from bottom. 10 sentences from bottom. My Lord, each sentence start. In any case, in any case, the transport system in a state is made for the benefit and convenience of the public. So that is the one of the law that is there and one of the principle behind this principle that the general public should not suffer. At least, my lord, the findings of the learning single judge, that, my lord, according to us, that is because this expression, such variation or extension cannot be limited to only providing further that second provides one and two. Because variation term, that is, my lord, the expression is that enactment subsection 3. The main enactment, an application to vary the conditions of any permit in this way. There are 3 modes mentioned there: extension, curtailment, addition of the. Now, just my lord, I should stress on the 2013 single bench order. Or judgment. A 2-page order, but it was, my lord, considered. It was considered by the learned single judge on earlier occasion in this matter when the earlier writ was moved. So kindly consider this. There also this question came up that the variation and whether curtailment includes variation. The Justice Dorfman said in 2013, 26 November 2013, second page, my lord, of the order. In my understanding, the Commission for the Section 80 of the Motor Vehicles Act combined application for curtailment of a part of the route and for extension of the other part thereof is not permissible in law. Curtailment and extension amount to variation, and variation is permissible keeping the termini of the route intact. Allowing the petitioner's prayer would amount to alteration of a terminus which is not permissible. So the single judge also said that curtailment is also one kind of variation of the parking condition. And that means variation of the.
What has the direction been given by the honorable single judge? What is the direction given by the honorable single?
Well, the direction was finding. Present repetition has been 127. The present repetition is allowed with the direction upon the Secretary Transport Department, Government of West Bengal. Consider the petitioner's prayer appraised in terms of tribunal provisions as well as laws in this regard at page 127. Present repetition is allowed with direction upon the Secretary State of State Transport Department, Secretary Transport Department, Government of West Bengal, not the HTA, to consider the petitioner prior affairs in terms of statutory provision. Now, since in terms of statutory provision mentioned there, now the Secretary Transport Department will have considered and rejected, even resorting to that, their public inconvenience, and they filed a writ petition. Now, in the midst of that writ petition, I took time, matter action, and filed this writ petition because unless and until so long this order remains, I cannot take any further play in the subsequent writ petition, where Secretary Transport Department has taken same point while rejecting. So I prefer this against the earlier one. My lord, my lord, that GT Baker Swami Reddy matter, my lord, the Supreme Court state that there should be a new application. Here the one of the issue was that whether variation
Only thing in the case is one paragraph at page 126. The second last paragraph, whether it is sustainable or not sustainable.
Fine.
That is all. That is all. The Honorable Single Judge held that curtailment of a permitted has not been made subject to any condition of life. Whether this can be sustained or not, that is what has.
There cannot be such a right of a party holder that you can apply as a matter of right for curtailment that would be granted. So no condition, no question on it.
Yes, subject to what?
Last office.
Page 100. Yes. Single judgment you are citing before division bench.
It says single judgment is under change.
No, but what this page
That is consequence of this report.
maybe, but today you are arguing before division bench.
There will be your option. This judgment is under change. There is a
Maybe that judgment is not binding on us. There may be.
there will be two judgment. One is of Supreme Court decision.
So that you show if you want to show.
That Supreme Court. The Sija
New party.
When you were arguing, he was not saying anything. Be patient.
I have only and my questions are one is this declare are notified to the other scheme. This formula 1939 Act. That one aspect is that the scheme has been declared by which the whole or area has been declared as nationalized. Here the exception has been given. Exemption has been given to some of the offenders who are already offending therein. Thereby, one answer has been given by this by the decision whether the application for extension should be treated as an application for grant of any permit. That has been decided. But for the other part, that has not been answered because that was the route is a notified under the scheme which has been declared as nationalized. So that answer has not been. Option B, fine. Actual mapping very good. I mean, of the judgment. Yes, but that is the actual mapping. Otherwise,
Yes, he was seeking extension of the route.
yeah, but I am thinking article.
That we have seen the fact. He was that case. He was seeking extension of the route. Yes.
Yeah, but
You were seeking curtailment.
that's not true.
Yes, and under 18, the moment you curtail, your termini will remain the same.
That
Cannot be.
even extension that cannot be.
Cannot be. Correct.
Right. Now that has been dealt with, check
The moment the termini changes,
that will not be treated. That is what it is. In extension, if I apply.
the moment the termini changes, what is the provision in 83? You read 80 subsection 3. What happens if a termini changes? 3, yes.
Yeah. That's an application for writing.
You are reading for us or you are reading for yourself? Yes, an application could vary. An application could vary.
Varying conditions of anybody.
Yes.
Other than a deliberate by or in new area or high ordinary or area covered by it or in specific number of above the specified or by variation, extension or cutting
Yes.
of the or the area specified in the part
Shall be treated as an application. The moment it is treated as a new application,
that has
the moment it is treated as a new application, can the judgment of the Honorable Single Judge stand that it is subject to no rider whatsoever? Now just tell us this, based on the statute.
yes, but that I because these two details are an application for grant of a new permit.
New permit is without any rider.
That has been answered in Siddha number.
We are not considering Siblok Chamansa. We are saying the Honorable Single Judge has said that this curtailment is subject to no rider whatsoever. A sweeping statement has been made of law which is now applicable.
Was my lord, I am unpaid.
Yes.
The riders which have been given my lord in section 8 subsection 3.
That is not the point.
These two riders have been given.
We are not considered with that.
So far as curtailment is concerned,
Curtailment is there in 83.
the statute does not provide the rider so far as the curtailment is concerned.
Oh, it does. Yes.
Now you are occupying come to where?
It is treated as a fresh application.
So that fresh application is not
Without any rider.
but that is not coming under within the purview of a section 8.
Cannot stand, sir.
Now one is
Cannot
number
stand.
you are occupying judgment. But I am relying on
The moment we certify that a new application is without any riders, then the entire statutory scheme will be upset. Cannot be. A new application can only be made when a study of all these issues have been made regarding the number of stage carriages already operating, more required, what is the condition of the route, what is the traffic, what is the flow of commuters. All this has to be done. Then vacancy has to be notified, and then the number of stage carriages as per vacancy has to be done. And the Honorable Single just says no riders. Now you tell us.
That is respect of the point at the other than those rules,
So therefore,
other than those, this is not a
so whatever it is, so can a curtailment be without any riders? It cannot
those
be.
riders only those riders are in under section. Now look at I come to section 80 also. Section 80 subsection 1.
Yes.
Now it is subsection. Yeah, the section 80 subsection 1. Subsection 2. Because subsection 2 provides provides, but the application cannot be refused only by the
Obviously, cannot be refused does not mean has to be applied.
no,
Has to be.
provide place where it cannot be refused ordinarily, where there is a section 71 subsection 3 or section 74 subsection 3 notification limiting the number of stage carriage and the contract carriage. But here these two,
Whatever it is, whatever it is, a new stage carriage cannot be allowed with no rider or without any compliance.
these amount to already belong. And yet, this is one.
If we allow the population to stand, then
If the new state carriage, assuming but not admitting this is a new state carriage, assuming that
how can you not?
they were the extension.
That is what they are.
Extension, which is an application for that one.
Yes.
Extension. What? Under section 80 subsection. There are three contingencies.
We are not considering extension. We are considering
there is the writer. Extend the route more than 24 kilometers.
No. Apart from that, the termini cannot change. Both.
No,
Not 24 kilometers, but
Yeah.
termini can change.
extension. The termini, one of the termini must be changed. In extension.
Yes, in extension, yes.
And not in
It's subject to 24 kilometers.
Yes. They were in variation. There is also 24 kilometers, there is the rider of 24 kilometers, and there is specifically pointed out that the termini shall not be, but that in respect of variation, you not find it. This two rider is there in respect of variation, one variation is respect of such as diversion. Variation here means subject to minor correction. Variation means diversion. In respect of diversion, the route must be diverted portion must be 24 kilometers and whether the timing shall not be altered. That is the value of rider and in extension 24 kilometers from the one of the country. That has been if the principle whether it is that the extension and variation is not an application as like as the grant of a new permit. And where the curtailment is not there. Curtailment is not there. But I there are three contingencies. Extension, curtailment. Yes. That one, uh, paragraph number 4, point number 2. This is start of the paragraph 15.
Yes, which paragraph? 15. Yes. That we have seen. this judgment you are saying? This judgment, what do you want to show?
Well, I am trying to establish that there are three conflicts.
You need not, that is there in the statute. All these three are quite apparent from the statute.
That will be cannot be treated as variation.
All right, yes, that is.
Then now we are of Section 17.
Curtailment cannot be treated as variation.
Yes.
It is a variation.
So that
It has to be a variation.
that there are three things in respect of settlement
Yes.
and in respect of variation
Yes.
and in respect of extension. There are three the words has been used. One is settlement, variation, and extension. That has been dealt with by the order judge. There are three things. One is
Only one thing distinguishes variation. In variation, there is no change of terminal.
yeah, and
That is
24
only.
kilometers. This side. And in extension also 24 kilometers, there the terminal, one of the terminal.
Extension
Now
and
you-
curtailment termini will change.
Yes. Now we are studying
But whether this is
no section 17. But very clear, you also can see, I am on these activities.
yes.
Section 17. Subsection 2. Now let's go XX item. Yes.
72.
Subsection 2. Now clause XX item. That's the third also push me after. Provided that the conditions specified in clause 1 shall not be carried so as to alter the distance covered by more than 24 kilometers, and any such addition in such limit shall be made after because certified that such addition is after. Now we are also planning subsection 1. So subsection 2, clause 1 is that a vehicle shall be used only in specified area or on specified roads.
Which provision?
In respect of
72, 22 you have shown. What is?
72 subsection 1.
1.
Yes. If the condition has to be varied in respect of subsection clause 1, then two things has to be considered. One is the variation must be within the limit of 24 kilometers that has been written by the XXIR, and the authority must be satisfied that such variation will serve the convenience of the public. Section 80 subsection 3. The word settlement your lordship will not find in section 72 subsection 2 exercise. So the word settlement is distinctly
How it can be? 72 deals with grant of stage carriage permit.
and the value of the comparison.
Correct. That is all. So that is a provision dealing with something else.
That
Section 80 is dealing with this aspect. Therefore, section 80 has this.
but that
This
section
need not be appearing in every section in the statute.
so
There is no requirement that the expression.
section 80 subsection first provides the rider is there in respect of extension, and second provides
That what you are submitting has been accepted.
that
That has been accepted by the honorable single judge. We understand what you are submitting. That has been accepted, but the result is an observation or a declaration that curtailment is subject to no riders whatsoever.
plus so far as the
We are on
yes,
this only.
only this thing so far
Yes.
as the statute is concerned,
Yes.
there is no right.
Or
There is no right. However, I am relying on the decision, other decisions, with regard to the legal. However, I am relying on the decision. of the volume 7, SCC 7 company. The other decision, they were paragraph 9.
Yes, the golden rule of plain reading.
What has not been heard, so I want the interpretation I beyond this book. And then that has been indicated.
So where the interpretation was called for.
So when a
If a
that
fresh application has to be made and it has to be considered as per the statutory provisions, where is the requirement of giving any interpretation?
face application has to be
That is the direction in your favor to make an application which is to be considered as per the statute.
that petition which is under challenge here, my lord, the judgment. Thereafter, they have taken a decision, and that decision is under challenge before the single judge, and that is pending. Where, my lord, they have stated again, the public confidence has to be considered. That is under challenge, but that is not the before my lord. The earlier judgment which is dealt with by the authority and considered and my lord rejected. So that is here. One thing, my lord, the lordship,
What is
I have not how my lord the cartel made. So far as the provisions is concerned, but the word cartel made in respect of that.
that we have seen, that is accepted by the honorable single judge. What you are arguing has been recorded and has been accepted.
I
Exactly in so many words.
only that writer. Your lordship is of the view that whether there cannot be any writer in cartel made.
You say yes, there is no right.
Because it is not appearing from the statute itself.
That is your specific stand. You said that yes, there is no right.
And that
Any curtailment has to be granted merely for the asking. This is your submission. The moment a person wants a curtailment, it has to be granted.
because
This is your submission.
Because if there is no otherwise,
If and but is not there.
Yes,
For a specific
because-
case is
yes,
the moment one tenders an application for curtailment, it has to be just signed and given back.
because when if there is no notification under section 71, okay.
That is your
that is the only rider. That is the only rider. Where my lord the 71?
Why is not material? Point is that is your case.
My lord. And my lord the statute does not my lord anywhere taken this rider so far as the variation and curtailment is concerned, so far as variation and which rider has been given in my lord the second and first and second proviso that has not been given to the curtailment. So the unit, my lord, assuming the curtailment, there is no limitation because it's 24 kilometers also not there.
So it can be 24 kilometers. Curtailment will always reduce. There is the question of 20.
If there
Curtailment cannot be beyond 24. It has to be within. Therefore, 24 is not there.
at the legislature,
What is it?
at the legislature,
Why the legislature should mention it? In the case of curtailment, why it should be mentioned? Curtailment will only reduce. Where is the question of limitation of 24 kilometers?
no, maybe, but that is
What
not
may
there.
be, it is
That
obvious.
is not there.
It is
That
obvious.
is not the intention of the legislature on my view.
Sir, curtailment itself means lessening.
Yes.
Lessening the existing. It has to be lesser than the existing.
So variation, 4 kilometers is what?
Variation can be beyond
No,
also. It can be.
no, that is there.
But variation, there is a possibility of being more than 24. In a curtailment, there is no possibility of being more than 24 because it will always reduce.
Variation is specified that it should be 20, it must be 20.
Because because for the reason that there may be a route of 23 kilometers and a variation of 2 kilometers will make it 26. Therefore, there is a limitation that it will not go beyond 20. In curtailment, there is no question of 24. It will always decrease. It cannot increase. Therefore, 24 kilometers has not been mentioned. What is the big?
Another aspect, but it's the theory, especially subsection. This it starts by inclusion of a new right? By inclusion of new rules, by altering the rules. These are all very separately to be considered. But so far as these three things are concerned, participant variation and extension. The other thing which has been well specified, an application vary the condition of farming other than temporary by inclusion of a new or route or a new area or altering the route.
So,
only one paragraph of the Evidence of Judgment. Then I handed over 1992.
this judge,
Yes, yes. 1991 SEC. Now what?
He has placed on a 26 judge. So far, they
no, he has placed this Mithilesh Garg judgment.
16 judgment. We are 26 judgment. He has placed.
He has placed the Mithilesh Garg judgment at the very beginning.
And they were 26, 8 to 26, 2016.
Yes, yes, that's your correct.
Yeah. Well, we had to kindly come first. Kindly come to 1991 SEC penalty made paragraph number 14. When the Supreme Court says that 1988 Automobile Act is a valid piece of legislation, now paragraph 14, the Supreme Court says, after 5-6 lines, the legislative policy under the Act cannot be challenged on this ground. It is not disputed that the Regional Transport Authority has the power under the Act to refuse an application for that of permit by giving reasons. It is for the authority to take into consideration all the relevant factors at the time of judicial consideration of the application for grant of permit. So my power is there with regard to whether the statutory office, the statutory authorities under the Act are
Not for, according to him, not in the case of curtailment. The moment he makes an application, you have to sign it and give it back to him.
But paragraph 14 is contention of the
Yes,
paragraph 14 is what he relied upon. That is not even a ratio. That is the contention of the yeah, started is the understanding. Started is the contention.
He started the petitioner's contention, but then there is the views of the court. When it starts that the legislative policy under the Act cannot be challenged on this now. These are all the view of the court. And the first 3 lines or the first sentence were the contention of
that's all.
fine.
So you have given the judgments. Once again, tell us.
That's 2016. Date is
One you have given of this Kerala High.
one is Kerala High Court, and
That you have given on the earlier date.
and that was considered. These relied upon 26. That is respect of a rule. It's a national line. So that will not applicable. That is another chapter, and this is completely another chapter. Only
We are only asking which judgments you have given. Give us slip. Give us slip judgments which we have given. Please, sir, give us slip. Take the trouble.
Only he takes his judgment. That's why I
Forget what he has done. He will say why you are saying. Yes, which we have said this in the next week for orders. The other case for orders. This case, next week for orders. This is judgment reserve. The other one for orders in the next week. The earlier one. Huh? Yes, give it. 18, 19. Huh? You want me to remember? You want me to remember what is the difficult? I will acknowledge this. Yeah, it's peculiar resistance. I don't know what to say. If the court was asking us like this, we could immediately do it without asking twice or saying anything. I have to ask you 3 times to do such a simple thing. Very unique resistance. I have never been. I have been there for more than 2 decades. Where you are, I have been there also for 2 decades, more than 2 decades. What a simple thing you are asking. Again, I will handle. The 20. Yes. Page. You were referring to some judgment.
And yes, the time subject we mentioned in favor of this the money common and very total of creation X are under state register sir we find mention of the context of the matter. I would like to state that government institution there are no public 1975 because after 45 years this service is not traceable at our office. Therefore, the consultant type of the question is made by our officials made vigorous service of the labor. So it cannot be ascertained whether this government employee channel or has not surrendered or had been then refunded 2 months emoluments on last pay drawn by the pensioner from under the party. However, the spirit and intention of the government order take 30 days have been dated 28 September 2023 and stands for the sake of security. The benefit of family pension has been extended to the unmarried order of government employees of the pension. Furthermore, the government of West Bengal municipal property grants find their number of has confirmed the reduction of 2 months minimum emoluments from the government servants for the education for the purpose of under the above circumstances, I would like to request you yourself the claim of Miss Inamani Portman and married daughter of great Ishan Chandru under the terms very sympathetically with the light of socio-economic security. This available humanitarian consideration is highly solicited accordingly. So that Miss Inamani Portman and married daughter of great Ishan Chandru X class of these offices may come under the party of the family pension benefit. My lord, because the certificate issued by the certification officer Malta at page 25 of the OA application Annexer G, page 84 of the application. Annexer G of the OA application. Page 84 of the application.
Yes.
This is certified that we have a promotion or number 6. Number 1 already on the then income of our family is from all sources. This is income certificate by the certification officer Malta. Then my application, the form of application 1026 is 85 of the application, page 85 of the application. Ishan Chandra Burman, my father expired on 12/1989. Surubala Burman, mother expired on 6/10/1987. Indra Mohan Burman, elder brother expired on 21/2017. Shanti Shekhar Burman, elder brother expired on 8/11/2009. Antipodo Burman, elder brother expired on 15/1/2013. Krishnapodo Burman, elder brother, aged over 65 years. Nirmani Burman, unmarried daughter, date of birth 27/1964. Where an affidavit to the first resolution has been approved by the other petition. And after that, we have the assistant secretary, my lord, page 89. Let's see, pension payment. May I show the passbook? My lord, kindly see at page 28 of the OA application.
We are not the pension sanctioning authority. And we are not here to verify your credentials. If there is a requirement under a rule of giving a particular document, can you get it without giving that document? That is the only issue. We are not here to certify that you are the correct person or that this is subject to
lordships and permission. Let the matter go out of prisoner. We shall file an application under the Act 2005. The accountant general government to post out of
Yeah, for what the writ petition should be kept pending.
and we are
If you don't get it, then what is to be done?
my lord,
Tell us what you want from us today, tell us. Suppose that you don't get it, what should be done?
my lord, pension payment
Without PPO, it should be given.
pension payment number, my lord, or number is there by the nomination form. And is the nomination form.
Everything is there. You yourself said that it is there in the AG office. What is the prevention from taking it from the AG office? Why you are shy of coming to the office?
5 days.
So it has to be there. It has to be there.
Kindly give a direction to the accountant general.
Why should we give a direction?
You
You have not tried anything. You are running between the tribunal and the high court. You are running one document you have to produce. The tribunal has said, come with the PPO, get the pension. Still you are not doing it. Not helpless.
I not have the correct copy of the video matter. How, where you know I can submit it.
We don't know. She has such good legal assistance that she is going to the tribunal and high court, but she can't get a PPO from the AG office. This is a bit difficult to accept. This is difficult to accept.
She tried have level based period. Why you have presented it
Yes.
to approach the AG office.
Where she has said this in the OA? Show us. In the OA where she has said that she has gone.
That is not missing.
What is this, sir? Are you like this?
My lord,
Are you like this?
my lord, kindly see the last time we learned.
What husband? Unnecessary you are
Yes, ma'am.
litigating in this matter for nothing.
Like this. My lord, please. My lord, Sundar Chakraborty, space, thank my lord.
We are not going to look into the documents. We are not going to certify anything. We are not here to do this. We are here to see what is the infirmity in the tribunal's order. That is all. Tribunal said PPO is required, go with the PPO. Why you will not go with the PPO? How the order is bad, tell us.
Employee my lord. Several times clerk, my lord, offered that case. My lord,
Everything you know.
my
No
lord,
instruction, no pleading, but everything you know.
my in the meeting that I have said that, you know,
What?
that several times I had one, jealous review, I submitted the jealous review.
Yes.
And at Telegram, I stated that.
Where is that?
Yes. Page 19, man. Page 11 is your paragraph 9. And the question also is that starts with the ardent soul pays the pension of her father. But the petitioner can pays out the pension of any other subsequent of her father other than this. Petitioner has not well second question. On several occasions after the death of petitioner's father, and as the house was submerged on several occasions, plus any papers and documents related to the service of the petitioner's father was washed away, destroyed.
Yes, what is the information in the tribunal's order? The tribunal's order. Where is this letter of the district registrar Malda, 12/3/2020? Where is this letter? Page 52.
Order.
District registrar Malda, 12/3/2020. Why you have not annexed the letter? Why have you not annexed the letter?
Yes. Annexment as
Sir, it is a one line. Please read what it says.
Yes, one. Yeah, that's an issue forward here. Letter.
Where is that letter?
Letter, my lord, assistant secretary. Assistant secretary. State register. Yes, 54.
4/3/2020.
Yes,
Page
yes, my lord.
53.
Yes, my lord. vacancy of the
The entire confusion, you have next all the documents in reverse order.
over application annex manner over application basic application over application is annex manner.
Yes,
Basic your income.
please use it down. So you have rejected, we have rejected our claim for family pension.
I am not, they have not rejected our claim for benefit. They have only asked for the SI documents.
What necessary document?
SI documents means the view of the rate fund.
Why can't you find it from your office? What is stopping you?
But in our office is not available.
Where have you said?
But in page 52,
No, you have not said it is not a bill.
but it is the district register, it is written by district register of the discretionary the state of West Bengal.
Yes, where have you said it is not a bill?
Yes, it is the first card.
Yes,
I think
service book is not traceable.
Yes.
Then you are asking her for PPO. You are not asking her for service book.
But so what video is not
But you have not said anywhere that PPO is not a bill.
had not been available, that would have solved the problem.
We don't know. Why? How can she be asked to give it? You find out.
So in our office, it's not, but it is not yet. Service book is here.
See, this is not a place where you can say whatever you want. Your officer has said that service book is not a bill. He has not said that any other document is not. The officer says service book is not available, and then he asks her for PPO. Why? Whatever document you have, ascertain whether she is the rightful claimant or not. You take a decision. Unnecessarily, this matter is pending for. If you whatever you have in your presence, you take it. You ask her to give whatever has to be given. There must be a procedure for processing the application. Where is the procedure? What is the procedure? I am asking him for so long. He is just trying to invoke the court sympathy. Repeatedly, I am asking you, what is the procedure? What is the procedure? Nothing. Now all in your mind. What is this? There is no such thing. There is no such thing, sir. That is what we are telling you again and again. This humanitarian cannot be extended to you whether you are rightful claimant or not. If someone who has died 50 years back, you are claiming family pension for that person. All of a sudden, after 45, 50 years, and then humanitarian 89, yes. What year we are in? Today we are in which year?
I have applied my
46.
2017. I have applied.
Correct. So after so many years,
About
you process the
I
claim.
get that.
You see, you cannot be granted everything only for asking. Be very clear. You have to withstand this. Take down. When we are asking you, then you did not show. We are arguing. We asked you 10 minutes back. You did not show. Page
99.
What does it say? Anyone who comes and claims it should be
45 years after death of, after 45 years of the death of the employee, the employee appointed shall leave it as a temporary porter. Challenge of the central tribunal Calcutta, Number 182 of 1996, delivered on 17 March 1996.
there is a question of delay.
Also availability of the record signed.
Yes.
The petitioner claims that her husband was responded as a voter under the Eastern Railways from 24 and was posted as a registered voter on 27th April 1962. Her husband died in Hamlet on 8 October 1965. No family pension or other certificate is paid to her. The petitioner claims that she learned for the first time in April 1989 that she was entitled to pension on account of the death of her husband. She therefore applied for the same. However, she was informed by a letter dated 12 February 1991 by the Commissioner of Administration of that she was not entitled to some pension as no records were available to the respondents in support of her claim. The petitioner submitted representations again in February 1991, April 1992, and October 1992. She was informed that it was not possible to pay her any amount either by way of provident fund, pension, gratuity, or ex gratia, as no particular certificate furnished by her regarding the service of her husband. Agreed by the decision of the respondents on her pension, she approached the administrative tribunal by preparing the aforesaid original application. The application has been disallowed by the tribunal. However,
Unnecessarily, you are reading this judgment. There is nothing in this judgment that without producing any document it should be paid.
I'm not telling that, but
Then why are you reading this? Where is the question of delay? Who has raised the issue of delay? Who has raised the issue of delay? Why you are reading this judgment? Has the tribunal said that your claim is belated?
no documents were available in the
No. The Supreme Court has said that you go and approach the authorities. It has not said to give the pension just like this. You are reading the entire judgment we have already seen. Come to the last. Come to paragraph 13.
in our opinion, once again.
Correct.
For payment of family pension,
Yes.
they should be because not actually.
So therefore, in your case,
he was a temporary voter, not permanent voter.
alright, that is enough. Yes.
My here my lord, this person has superannuated after exerting more than 30 years of service. And
What are you arguing, sir? Who has rejected your claim? Has your claim ever been rejected? That it is belated, it is barred by delay, you are relying on judgment or delay. We don't know what kind of there is only one thing, whether you are to certify your identity or not. That is all.
here also, a record, claim was refused on the ground.
No, it was not. It was refused on the ground of delay. You read the judgment.
She was informed by letter dated 1981 by the Commissioner of Education that she was not entitled to has no record where available with the respondent.
Come to paragraph 11. Come to paragraph 11.
Submissions of Mr. Bhattacharya for the respondent for 5 years is entitled the petitioner to educate filed by the respondent 6 years. Petitioner has applied for the
Only issue of delay has been considered by the apex court. Nothing else. You are unnecessarily you want to read the entire judgment for no purpose. Futile exercise. It is only dismissed on the ground of delay. That is not your case. In their case, your case, they have not rejected. They still want to do it, but you have to certify your identity somehow. Then we can't help you. If you have nothing, then we can't help you. Right. That is enough. You are the custodian of PQ.
It's not been decided. So state authority is concerned.
Who is the competent person? This district registrar. District registrar is the competent person. Go before the district magistrate.
Even on the there was a complicated submission of
Where is that? We will not consider anything which is not on record. Sorry. Yes.
we have a specific task for the
Counsel for the Without being prejudiced by what? What observation we have? Any of them?